Good morning, everyone, and welcome to today's insolvency webinar. I'm Clay Askew, a director in the firm's restructuring and insolvency team.
Good morning, everyone. I'm Gawain Moore, a partner also in the insolvency and restructuring team, specialising in all aspects of contentious and non-contentious insolvency. Claire's going to do most of the talking today, but I'll be chipping in every now and again with a few comments and anecdotes. So Claire, do you want to start by telling us what we're going to discuss today?
Yeah, it's probably worth setting a bit of the background and the rationale for today's webinar. So we're currently in the midst of a pandemic which has resulted in unprecedented levels of government support and intervention. The current economic outlook is such that companies have benefited from support by way of items such as the furlough scheme, the deferral of VAT, bounce back loans, the coronavirus business interruption loan scheme, and business rates relief. And there's also been a moratorium on the taking of certain enforcement action. And all of these measures have significantly assisted businesses as they navigate their way through the pandemic. Now, it's worth noting that those support measures are gradually coming to an end. Today, 30th of June, was originally due to be the date on which some of the moratorium measures ended. Some of those have now been extended, but it is important to note that some are changing. VAT deferral is now coming to an end. The terms of the furlough scheme change tomorrow, and employers are required to contribute 10%, and that then increases to 20% in August. Some of the business rates relief are also ending. So it is expected that those measures, as they come to an end, will have an impact on businesses. And obviously, we can't mention the economy without still touching on the Brexit and the long-lasting impact that might potentially have as well. Gawain, do you want to add anything to the background?
Yeah, I think it's fair to say it still feels a bit like the calm before the storm, but what the storm will ultimately look like is somewhat unclear. Will it be a sort of wholesale collapse with multiple administrations and liquidations, or will we see a more wide-scale use of CVAs and restructuring plans that we'll come on to talk about in a bit, which could be a method to deal with what we refer to as the COVID debt, the debts that haven't been paid for 18 months, the debts to the landlords and the suppliers, where there's been some forbearance for a period of months. We are in dialogue with key stakeholders, with lenders, with insolvency practitioners, and the general consensus is that insolvencies will rise, but when that's going to happen, whether that's next month, 3 months, 6 months, we just don't know. But today's webinar is designed to give some insight into some of the key issues that will arise when those insolvencies do pick up. So Claire, what are the things we're going to cover today?
Yeah, so I'll just talk us briefly through what we're going to cover today. So we'll have a section dealing with how to identify risk areas and how to take steps to protect your business. We'll also deal with some formal insolvencies and what steps you should be taking as a creditor. And then finally, we will come on to potential opportunities as well. It's not all doom and gloom. Okay, so how do you identify if a company is in financial difficulties? Some of these items might be quite obvious. So, for example, erratic payments. Now, what do I mean by that? That might involve missed payments, partial payments, delayed payments. So it's a one to keep on your radar. Now, changes in contractual performance is an interesting one, and what does that involve? That could, for example, involve missed deliveries or delayed deliveries. It might also result in a change in approach from a particular supplier or customer. And by that, I might mean the approach might become a little more formal. So, for example, you may have previously had a relationship which involved, informal telephone conversations. There might be a move towards the use of emails to try and create a paper trail. The tone of that correspondence might become more formal, which might be an indication of professional input. Customers or suppliers might seek to become more contentious. And by that, I mean they may seek to argue breaches of contract with a view to potentially minimising their own exposure or liabilities. And changes in key personnel is often a good indicator, because it might be a sign of cost-cutting exercises or redundancies, or also employees losing faith in a business. And then it's also worth noting other publicity. So in terms of press, that can often give an indication of underperformance. And then public sources of information, such as, for example, Companies House. So if a company is granting new security, that needs to be registered, and that can often be a sign of additional borrowing. So that's also a potential warning sign. So what do you do if you do identify that a company is experiencing financial difficulties? Well, one of the first things to think about is whether you can renegotiate your trading terms. So don't necessarily think that that is not possible. So that could involve changes to payment terms or delivery dates. But the important point to note is that if you are considering a change, it must be properly documented and it must be timed correctly, i.e. prior to any formal insolvency commencing. And documentation is key because changes to contracts could potentially be challenged, but the likelihood of challenge will be minimised if there is a paper trail which properly documents the rationale for the change. And that rationale might be you exerting commercial pressure on your trading partner. Retention of title is an important one, and we're actually going to come on to that in a little more detail. But what I would flag is, if you do think you have retention of title, to check the actual terms at the earliest opportunity, so that you can analyse whether they are effective. Another key point is considering the wider contractual terms, and again doing that at the earliest opportunity so that you actually understand what a contract says, and checking contracting parties. Now, the reason I mention that is some of you on this attending this webinar today, there will be a group trading position. And what that means is you might have one group company which is a purchaser of goods, and you might have another group company which is a customer of the same third-party organisation. Now, you might think that you have a set-off position, but it's worth noting that the set-off rules in insolvency are actually set out in the Insolvency Act. So you need to make sure that there is not a mismatch between different trading entities, because you could be faced with a situation whereby one group company is required to pay money to an insolvent company, and that insolvent company at the same time owes money to another company within your group. And that can be addressed by way of options such as intergroup assignments. But those are things which must be carefully documented and considered and entered into at the right time. But it's just important to know that there are options. And then a final little point on that slide is in relation to contingency planning. Now, if there is the opportunity to speak with alternative suppliers or customers, if you are able to do that at an early opportunity, it potentially reduces the likelihood of you having to either pay a premium or potentially sell at a discount. So again, commercially, that's worth considering. So I touched on retention of title. So what we need to consider is whether retentions of title are effective and what those terms actually look like. Now, I'd suggest an early review of the terms so that you understand exactly what they say. For example, are they all monies clauses which provide for a customer not to receive title until it's paid for all of the goods? Or is it a simple clause which states that a customer will get title when specific goods are paid for? Does it allow you access to a buyer's premises to collect goods? Does it provide for the right of termination right to possession to terminate on insolvency? Does it provide for a customer to store goods separately, potentially leave them in certain packaging so that they're easily identifiable? And then one of the key points is actually checking that the retention of title clause is properly incorporated. And that might mean that there's an express incorporation in the contract, or it might mean that you have to rely on a course of dealing. Now, Gwen, you're going to just talk us through some examples to show why a careful analysis of retention of title is important.
Yeah. I think the point I want to get across is just because you think you currently have ROT terms with your counterpart, don't assume that you'll be able to enforce them, or indeed if you have a very aggressive lawyer on your side, that you'll be able to bully or scare the administrator or liquidator into doing a deal. The anecdote here is a couple of years ago, we were appointed to advise one of the big four firms on the administration of a large online retailer. That retailer was owned by a very successful private equity investor. It showed no previous signs of distress and traded with all the largest counterparties and suppliers. At the time it entered into administration, it owed millions of pounds to those suppliers, and almost all of them, without failure, attempted to assert retention of title terms against the administrators, either to try and just generally mitigate their loss by seeking to collect the stock or seeking a payment, or alternatively to protect the value in their stock because they wanted to prevent the administrators doing what administrators and liquidators do and selling off the stock at a discount, and they argued that would potentially devalue their brand. The administrators, despite all of this pressure, stood their ground on the basis of the advice from us on the effectiveness of the ROT provisions, and the outcome was that not a single penny was paid to any of the retention of title claims, nor any stock collected. Each of the suppliers was left simply with an unsecured claim in the business. If we look back at it, it was almost a textbook of how not to incorporate and enforce a retention of title claim on the part of the suppliers. There was out-of-date contracts, there was battle of the forms with ROT terms on the back of invoices, arguments regarding unregistered charges, all of which effectively went to the position that none of them could assert a genuine retention of title claim. So staying with contractual rights, we'll now have a look at termination rights in insolvency. So insolvency termination rights are sometimes called ipso facto clauses, and typically those clauses either provide for automatic termination on insolvency or another event, and more often than not, insolvency gives the other party the opportunity to terminate. You may have heard ipso facto clauses in the news 12 months or so ago when the Corporate Insolvency and Government Act, or CIGA, came into force. And the effect of that act is that suppliers will find it very difficult to terminate contracts for goods or services on the basis that the supplier has, so on the grounds that the customer has entered into insolvency. I should add that to the extent you're involved in financial services, different rules apply, and we can cover those perhaps separately. The restrictions only apply to the supplier, so customers are not prevented from exercising a contractual right to terminate. And what the Act says is that any contract that provides for automatic termination of a supply contract or allows the supplier to terminate based on the customer entering insolvency no longer has effect. The restriction also prevents the doing of anything other thing based on insolvency, and that could include the change of contractual terms. So if you're going to try and put up your prices as a consequence of your customer's insolvency, that will not be effective. A supplier also will be unable to rely on a contractual provision that would have allowed them to terminate the contract because of an event other than insolvency occurring before the insolvency, where the entitlement arose pre-insolvency but was not exercised. So if, for example, the contract allowed a termination for late payment, and that right wasn't exercised pre-insolvency, the supplier couldn't rely on that right after the insolvency event. The key point is that as a supplier, for those of you who are suppliers, you might be required to continue supplying even though you have a contractual right to terminate and you are owed significant amounts of money. That is why it's key to be proactive where this situation arises and not lose the opportunity to take action. I'll pass over to Claire.
Yes, and as Gwen said, don't lose the opportunity to take action. So that might be that you need to be on the ball and take an action a little bit earlier in the process before it's too late. So in order to do that, again, we can't emphasise it enough that you should be checking the contractual terms. And if there is a right to terminate in relation to an event linked to insolvency, so for example, a right to terminate if a company takes steps with a view to appointing administrators, for example, well, that is a specific right. So you do need to check that your termination provisions are appropriately wide to enable you to benefit from a termination right before it's too late. So again, a review of terms is key. Now, often using the threat of termination is helpful. And the reason I say that is that can exert some commercial leverage and might put you in a strong negotiating position. Now, you should also consider whether terminating is the best course of action. So if your contract is crucial to a customer or a supplier, then the termination might actually force the company into administration and therefore crystallise your loss. And another point to take into account is whether a live contract actually has more value. And we'll come on to that a little later when we talk about opportunities. Right, so we're now going to talk a little bit about transactions which are vulnerable to challenge. Now, you might think that if you are trading with a company in financial difficulties and you receive a payment from that company, that's a positive thing, and it often is. However, if you receive a payment from a company and that company does not pay all of its creditors, then there is a risk that if it subsequently enters into an insolvency process, that the payment to you could potentially be challenged as a preference, which is a concept of challenge under the Insolvency Act. Now, there is a way to mitigate that risk if you can demonstrate that the payment was made as a result of an agreement with the company and you exerting commercial pressure. But what is absolutely key is that that must be documented and there must be a paper trail. And the reason that that is particularly important is that if a transaction is successfully challenged, then it does result in a potential clawback and you having to repay monies. If a company is subject to a winding up petition and makes a payment to you, then that payment is also vulnerable to challenge. And that's because there are provisions within the Insolvency Act which state that if a company disposes of property, and a disposal of property also includes a payment of cash, at a point in time after there is an outstanding winding up petition, then that disposal will actually be void and you'll be required to repay it. So as you can see, that's far-reaching consequences. And Gwen, you've actually got recent experience of dealing with exactly that point.
Yeah, I have. This is probably a reminder of the harsh reality of insolvency for creditors, and what the law says in terms of there's always a loss. That's what happens in an insolvency, but how the loss is shared. And the law says that where there is a loss, it should be shared ratably, and that's what the Section 127 post-petition challenge law seeks to address. So my next little anecdote is in relation to a liquidation on which I've been advising for the last 5 or so years, involving what was previously one of the UK's biggest IT distributors. The company went into liquidation in 2015, but the winding up petition was actually issued some 18 months earlier. And in that 18-month period, the company continued to trade with its suppliers. During that period, void payments to the suppliers were very, very significant, exceeding £50 million. And it was an unusual liquidation, or is an unusual liquidation, in the sense that there was actually only one creditor in it, being HMRC, who owed the best part of £40 million. So you've got a situation where one creditor has been left out, whereas all other creditors have been paid in full, and that's the situation Section 127 seeks to address. The key point, and the sort of harsh reality here, is that each of the suppliers in the post-petition period continued to trade with the company in good faith for value and with no knowledge at all of the winding up petition. And the court had in fact ordered that the petition not be advertised, as it was disputed after it was issued. Where have we got to on the liquidation? Well, despite the suppliers in question being some of the world's largest IT companies, advised by some of the world's most aggressive and reassuringly expensive law firms, not a single one of them has applied to court for a validation order, because they know it is unlikely, based on the law as it stands, to be granted. And the effect of it has been that each of them has entered into settlements with the liquidators and repaid millions and millions of pounds of the void payments they received. So the key point here is that one, don't assume that a liquidator will not pursue void payments, and then secondly, where there is a liquidation like this, the loss has to be shared ratably, and if you've been paid in full, the law says you have to pay it back, and then it's redistributed ratably amongst all the other creditors.
And it's just worth the final bullet point on this slide there, just in relation to wrongful trading. If a company is facing financial difficulties, then the duties of directors do change, and it's worth bearing that in mind if you are trading with a company who you consider is facing insolvency. to make note of their conduct, because that might be something which you want to flag to an subsequent insolvency practitioner.
Okay, so what are the insolvency proceedings we've been hinting may increase significantly over the next few months? Well, we have a number of different insolvency processes in England, and we could and indeed have spent webinars talking about each individual insolvency process. We've listed the main ones on the slide, and we're just going to talk through each of them briefly. Just as a reminder of what they are, or in the case of restructuring plans and moratorium, it might be the first time you've become aware of them.
Okay, so I'm just going to talk through administration, which is one of the more common forms of formal insolvency in England and Wales. Now, an administration process involves the appointment of an administrator, so an accountant. And that administrator takes over the day-to-day running of the business, and directors will lose their powers. Now, the first statutory purpose of an administration is for an administrator to try and rescue the business as a going concern. And then failing that, it is to achieve a better outcome for creditors. And if that can't be achieved, then to realise assets for the benefit of a secured creditor. Now, in order to help an administrator achieve that first purpose of rescuing a business as a going concern, there is a statutory moratorium on the commencement or the continuation of legal proceedings and enforcement action. So that's effectively to give the company some breathing space. But what that means for you as a creditor is that you cannot take legal or enforcement action either without the consent of the administrator or the consent of the court. It is worth noting, if you simply have a monetary claim, i.e. you have an unpaid invoice, then you are unlikely to receive consent. The situations in which you are more likely to receive consent are a landlord type situation, when you have a proprietary interest, so for example, trying to forfeit and regain possession of a property. Touched on retention of title earlier in the webinar, and we're going to come back to it again. Key message is don't assume that an administrator will be aware of your retention of title. So it is vitally important that you notify them of it as soon as possible. And the reason for doing that is it avoids the risk of the insolvent company actually disposing of your goods. So put the administrator on notice as soon as you can. Now, typically what will happen is an administrator will ask you to provide details of the ROT clause. And again, that's why it's important to check early on in the process and make sure that you have the relevant paperwork readily available. You might be asked to fill in what's commonly known as an ROT questionnaire, and that's effectively the administrator asking you to provide full details of what the ROT clause looks like. And it's not unusual for you to be asked to continue trading with a company in administration. And actually that can be beneficial. Now, the reason I say that is if you are required to continue to supply services or goods to a company in administration, then you have an entitlement to be paid as an expense for the goods and services provided during the course of the administration. Now, what does being paid as an expense mean? It effectively means that you are paid ahead of other creditors. But it's always advisable to have that put in writing with an administrator and actually have it documented, if at all, possible, just so you've got some assurance that you will actually be paid. And it might also be that you have a ransom position. If an administrator views your contract as being vital to the continuance of the business, then again it might put you in a strong negotiating position to potentially renegotiate your trading terms. And then the last point on the slide there is we've mentioned proving debts, and the concept of proving debts is effectively submitting a proof of debt to the administrator to provide details of your claim, and you're usually asked to deal with that pretty early in the process, and it's always advisable to provide full details so that an administrator has an understanding of the value of your claim. So we're just going to move on to the next process, liquidation, which Gwen's going to talk us through.
Yeah, liquidation is a fairly straightforward procedure compared to the complexities of an administration or CVA, or indeed a restructuring plan, which we'll come on to shortly. And it's probably familiar to people in that it is a procedure whereby the assets of the company are collected in, realised and distributed to creditors in accordance with their claims that they have submitted. There are two different types of liquidation. There's a compulsory liquidation and a creditor's voluntary liquidation. There's also a solvent liquidation procedure, but we'll not cover that in this webinar. Compulsory liquidation is probably the most important in terms of the commencement of it, because it follows the issuance of a winding up petition, which I touched on earlier. So that's where the potential for void dispositions arise, and it involves the court appointing a liquidator, with the official receiver being appointed initially, and if it's a complicated liquidation, then an independent insolvency practitioner will then take the role. In a creditor's voluntary liquidation, the company nominates the liquidator, but creditors must approve that appointment by way of a vote. That is helpful if you have a concern about the events leading up to the liquidation, or a concern about the identity of the liquidator. We often see cases where the suggestion is that the liquidator might be a bit too close to the company and its directors, and may not be quite as impartial as he should be in investigating their conduct. A liquidator is appointed if more than 50% in value of the votes are cast in favour of appointment. So what that means is if the creditors can generate sufficient votes, they could block the appointment of the proposed liquidator and appoint their own. As with administration, the process in terms of submitting debts is similar. So creditors submit a proof in the liquidation and relevant documents to back up that proof. And it is important to do that so that the liquidator is aware of your claim and can take it into account if and when there is any distribution to be made to creditors out of the liquidation. That's the sort of straightforward process. Getting steadily more complicated. I will deal with CVAs.
Yeah, so company voluntary arrangement. So this is probably one of the insolvency processes you have heard about, particularly in the last couple of years in the retail and hospitality sector. And a CVA is a process which allows a company to compromise its debts. Now, if you are a creditor, you will receive a copy of the proposal document, which is normally a chunky document, sometimes stretching to a few hundred pages. Now, that proposal will land in your inbox, and what you should not forget is that don't assume that the terms of the CVA are a foregone conclusion, because there is actually the opportunity to propose potential modifications to the CVA terms, and Gwen, we've got experience of doing exactly that.
Yeah, we have. So as Claire hinted, often unless there's been a press leak, which is rare unless it's a very high profile company, often the first you'll hear of the CVA is when something, a link to the CVA drops into your inbox, or sometimes you'll still get the full document itself. And they are long, complicated documents. Some might speculate that they're designed to scare. The message on the front is that the company is doomed unless you vote in favour of it. But if you vote in favour of it, then you'll get a few pence for your debt that is better than getting nothing. But you shouldn't assume just because they look often like big glossy documents that cannot be negotiated that you can't put in your own amendments. And we do have pretty wide experience actually of acting, but on both sides actually, both for the company who's proposed the CVA and creditors who've received it and have concerns about it. Probably the best example over the last couple of years is the earlier New Look CVA, where our clients were provided with a typically enormous CVA document, but only found its way to us a few days before the vote, so we had to get our heads around it pretty quickly. And having reviewed that document, we had concerns as to the effect it may have on our client, effectively for technical grounds, and we considered that there were flaws in the document that needed to be rectified. So we entered into dialogue with the company and its advisors, and they were actually quite receptive to that dialogue, because ultimately they didn't want a document that was going to be challenged. And we ultimately attended the creditors meeting in London and convinced them to circulate a amendment to the document in the sort of literally the last few minutes leading up to the CVA vote taking place. And the vote that took place was based on the amended document that we'd agreed. And the important point was that amendment was potentially the difference between our client receiving a full recovery on its debt effectively from a third party, or the alternative under the CVA, which would have meant it just receiving a small dividend on its claim, and the potential claim against the third party being compromised.
Yeah, the votes required to approve a CVA are that it requires the approval of 75% or in value of those voting. So you might assume that your vote is not important, but actually that is not necessarily the case, especially in smaller CVAs, and especially if you are owed large sums of money. So it is worth probably considering whether you should be voting and approving or rejecting the CVA document. A key point to note in relation to CVAs is that if they are approved, they are binding on all creditors. And by that, I mean those creditors who have voted in favour, those who have voted against, and also those creditors who have not voted at all. So it's therefore important to understand what the CVA document actually says, in order to understand what your rights and obligations are, but also importantly, when or if you will receive a payment. So it's a chunky document, but it's worth trying to get your heads around. And then we're going to come on to restructuring plans.
Thanks, Claire. Yeah, restructuring plans are like the sort of newest and most popular tool in the toolbox of insolvency practitioners, so we get very excited about it. It's like a CVA, it's a procedure involving a compromise between the company and its creditors, and it is available for companies that have encountered or are likely to encounter financial difficulties, and the access is likely to affect their ability to carry on business as a going concern. Unlike a CVA, to become binding, the plan must be sanctioned by the court, and for that reason, that probably will be less popular than CVAs. And to date, restructuring plans have only been used by relatively large companies with fairly complex debt structures, but there is thought that that may change, and ultimately, when the procedure becomes more common, that it may filter more into the mid-market. The process involves what's called a cross-creditor cram-down, and creditors and shareholders are split into classes for voting purposes, and it requires creditors and shareholders in each class to vote on the proposed plan. And like a CVA, it requires 75% by value of the class to vote in favour. Notwithstanding, and this is the key point, that a particular class doesn't vote in favour, creditors in that class may be bound by the plan if the cross-cram-down rules are met. And those rules are that at least one creditor who would receive a payment or have a genuine economic interest in the company in the event of the relative alternative voted in favour of the plan, and dissenting creditors would be no worse off under the relevant alternative if the plan is rejected, i.e. if there is a formal insolvency. There's actually been quite a lot in the news this week, and we've had the first court case where the court has refused to sanction a restructuring plan because the any worse off test wasn't satisfied. That's a case called Hurricane Energy, and no doubt if you get insolvency bulletins, there'll be a lot of discussion over that over the next few weeks. As with a CVA, of course, don't assume that your vote does not count. And given the complex voting structures, it may well be important. Again, like a CVA, if it's implemented, it will bind all creditors. So it is important to understand the terms of it and what impact it has on your rights.
I'm going to now just talk about the moratoriums. This is the last insolvency process we'll talk you through. And as with restructuring plans, this is another new process which was introduced by the Corporate Insolvency and Governance Act and was brought into force in June 2020, so we're 12 months down the line. It effectively is a process which allows companies experiencing financial difficulties to have a breathing space from creditor action to allow them to effectively turn around the business and allow them to continue trading. The running of the business remains in the hands of the directors, albeit there is the supervision of a monitor who will typically be an insolvency practitioner. The process involves a moratorium, as with an administration, and that prevents creditors, again, from commencing or continuing legal or enforcement action. So it effectively gives the company that breathing space. The moratorium initially lasts for a 20-day period, and it's worth noting that 20 days can be extended for another 20 days without requiring any consent of third parties. And there is also then a subsequent opportunity to extend with creditor consent. One of the important aspects of a moratorium is the treatment of debts and the categorisation of debts, because a moratorium distinguishes between pre and post moratorium debts, and there are different rules as to what amounts are paid and when. And that is going to be particularly important if you continue to trade with a company in moratorium. So you need to have an understanding of when debts accrued and when they fall due for payment. So keeping track of invoices and supplies is going to be important for those purposes. Okay, so we mentioned at the start that we'd also come on to some potential opportunities, and whilst insolvencies inevitably cause inconvenience, it's not all doom and gloom, and they do sometimes present good opportunities. So, for example, if a key supplier goes into administration, for example, you might want to consider buying the business and assets of that company and bringing the function in-house. And acquisitions from insolvency practitioners can often be quite attractive, especially if you, as a potential purchaser, have knowledge of the particular sector in the industry, so making you a special purchaser. And goods and assets are often competitively priced as well. So that's quite a helpful tool. Now, if you are trading with a insolvent company, we touched on this earlier, that there is potential to renegotiate your terms if you are effectively a ransom creditor. And I'd also add as well that if there is a business transfer to a third party, that your contract will not automatically transfer to that third party purchaser. Now, if that purchaser considers your contract to be of importance and would like it to continue, then they may seek your consent to an assignment of the contract. And you could potentially exploit your commercial leverage at that point and seek to renegotiate terms in exchange for agreeing to an assignment. I just mentioned about the potentially the insolvency of suppliers, and it's worth not ignoring the fact that actually it potentially presents a good opportunity to remove competitors from the market. And Graham, you've got some examples of that as well.
Yeah, it's sort of linked to the first opportunity being the acquisition from insolvency practitioners. So you might look at an acquisition as a way to sort of build up the business, but an alternative is it may enable parties to remove a competitor from the market. And I think maybe a good example of that is the sort of retail sports equipment and apparel market, that if you looked back 20 years ago, for those old enough to remember, it looked very different to how it looks today with, for example, household names such as JJB Sports, with hundreds of stores on each high street, and big sort of internationally known brands such as Lily Whites, all of which have disappeared. And we're left with sort of, if we look at the market now, we've got sort of 2 or 3 big names, with the likes of Sports Direct and JD Sports dominated the market. And one of the ways they've reached such dominance is by buying up distressed companies, and in some cases removing them and their name from the market. So if we go back to the 2 retailers I mentioned earlier, JJB was and I believe also Lily Whites actually was bought by the Sports Direct group, and the names are no longer used. Certainly JJB has disappeared completely. So that's one significant competitor removed from the market.
The final slide today talks about facing financial difficulties. Now, hopefully, this will not apply to those of you on today's webinar, but it is worth touching on what to do if your own organisation faces financial difficulties. It would probably be remiss of us not to touch on that just very briefly. And the key message is to take professional advice. Advisors can help navigate you through what is often a very difficult situation, and can help provide input in relation to restructuring options or potential contingency planning. And that taking of advice is especially important for directors, because the duties owed by directors do change in circumstances where a company is in financial difficulties, and those duties are owed to creditors rather than its shareholders, and there is a potential risk of wrongful trading. So it's very important to get that advice again at the earliest opportunity, because that helps directors demonstrate that they are taking their duties seriously and have obtained appropriate advice. So that brings us neatly to the end of the formal part of the webinar. Now, we have got, I'm just checking the time, we've got a few minutes just for questions at all. I'm just going to look whether we've had any submitted. Yeah, so let's have a look. So do we think that the COVID-linked restrictions will be extended again? Graham, it's crystal ball time.
Yes, I mean, it's the question that keeps being asked, but it's difficult to see how there won't be some form of extension. So the restrictions on winding up petitions currently in place until September, but I believe there is legislation in place to allow them to be extended again, and forfeiture restrictions until March next year, I believe. I think for those who saw Breakfast News this morning, actually, they were interviewing the manager of a nightclub in Leeds, who was explaining the huge challenges they've had. Whilst we're back in the office to a limited extent, and you see restaurants and pubs are open, there are industries which are not very relevant to me these days, but nightclubs are completely shut still. And Breakfast News also interviewed a sort of events company that does huge, great events, and they were talking about needing to take further loans to support them through. And it's difficult to see how businesses like that will be in a position to just continue to trade normally in September. It's not long now for businesses that have taken on millions of pounds of debt. So my feeling is that the restrictions will be extended. They've got to stop at some point, but I think probably the restriction on winding up petitions will be extended.
And it's probably worth noting as well that so the restriction on winding up petitions was due to expire today. It was extended 2 weeks ago, but when it was last in place, the government has been known to extend it the day before it's due to expire. So again, hopefully we'll get forewarning, but there's often been a lot of last minute decisions here as well.
Yeah, and I think the government did say when they extended it, it would give time for, I think they were talking about landlords actually, but landlords and tenants to agree what they were effectively going to do about the rent that hadn't been paid for 18 months in some cases. And it's a rather simplistic way to look at it, that give them a couple of months and millions of pounds worth of rent will just be agreed to be written off or compromised or whatever they think is going to happen. So that comes back to how we started the talk as to what are we going to see. Well, it does feel like if we're not going to see a lot of formal insolvencies, there may well need to be a lot more sort of CVAs and restructuring plans to deal with this debt that has built up, and ultimately it hasn't been compromised, it just hasn't been enforced.
Yeah. Okay, thanks, Graham. And then the next question is, you've mentioned a couple of new insolvency process. Will they become widespread? Is it worth me just mentioning about and some of the statistics? So we touched on restructuring plans and moratoriums. Now so they were both introduced in June 2020, and we have had 9 restructuring plans so far, although it's not quite clear whether the one which is currently going through the courts is included in that 9. And then we've had 4 moratoriums. So I think there's a lot of discussion, particularly around the use of restructuring plans and whether they will become widespread more so in the mid-market, or whether they'll stay at the complex debt level.
Yeah, I think I think we will see more restructuring plans. They are certainly a mechanism that that the insolvency legislation has required, and similar to what can be done in the US, so the cross cram down procedure. We would like to see them used more or used at all, actually, because we haven't had one yet, but in the sort of mid-market. And I think they will come, but it'll take some time, certainly a good few months, maybe longer, for the sort of documents that are required to become more mainstream. So advisors aren't starting from scratch, and they sort of know how the court is going to approach these things, and that should assist in bringing the costs of them down, because you're talking very significant amounts if you're a company going to propose it at that. So if you're in the mid-market, it just doesn't seem financially viable for you to propose that sort of thing. You're more likely to go down the sort of particularly if you want to compromise equity, you're probably going to go down the administration pre-pack route rather than a complicated restructuring plan.
Yeah. And then the next question we've got is, so actually it's a in relation to a point we've not done, but a reference in relation to are there new rules in relation to pre-packs?
Yes.
Which there are.
Yes, so came into force at the end of May. They don't seem to have had a lot of publicity outside of the insolvency profession, possibly because the number of pre-packs has been significantly lower over the last few months as a consequence of the government support. But the new pre-pack rules prevent a pre-pack of the company's business and assets to a connected person unless there's effectively an approval process that goes through. There was something similar put in place a few years ago with what's called the pre-pack pool, but it wasn't mandatory and was hardly used at all, whereas this is a mandatory procedure that obliges the process to go to an independent evaluator prior to it taking place. So it's important to remember that. What it's designed to prevent is the sort of Phoenix scenario where you have insolvent company that pops up the other side with the same shareholders, the same directors, and effectively the same name, but having left behind a significant amount of debt. It's designed to prevent that happening without some independent evaluation of the proposed sale. It comes back to my comment about there's always losers in insolvency, and it's unfair. As long as the process is that it is the best for creditors and it's not, for want of a better expression, a sort of stitch up, then there is a place for pre-packs, because ultimately if it preserves a business and jobs in doing so, that must be a better thing than the liquidation alternative of the business and company and all the jobs just disappearing.
I'm conscious of time that we've reached 10 a.m. Which was that was the scheduled end date, so I don't want to keep you all from your busy days. We have got another couple of questions, so what we will do is we will pick those up separately on an email and come back to you on those points. And we will also be sending out a follow-up note, which is just some key takeaways and some hints and tips, so dealing with insolvencies of suppliers or customers. So I think it just remains to say thank you all for your time today, and have a good day.